Thank you, Chair, and thank you, ERA, for having invited me to speak about this eternal topic of the interplay between the Brussels regime and the insolvency regime, the subject which has produced the largest load of the case law when it comes to the interpretation of insolvency regulation in general, both the original one and the recast one. In my previous professional career, when I was a national judge of the Supreme Court of Lithuania, we had two occasions to address preliminary questions on specifically this point to the Court of Justice, which resulted in two wonderful cases, Nickel and Goldner's petition, the first case, and the FTEX, the other case. Just to remind you, Nickel and Goldner's petition was the case where the Court of Justice for the first time introduced the notion of the procedural context as being an irrelevant factor for determination whether the action derives directly from insolvency proceeding and is closely connected with them. And the FTEX was the case where the court found that the close connection between insolvency proceedings and the action could be broken if the claim of insolvency administrator is assigned to a third party. It is true that there haven't been any cases on any judgments, at least specifically to this topic for a couple of last years by the Court of Justice. The two last judgments, BNP Paribas Fortis and Real, the date both from 2019, and I will use both of them in my today's presentation. There is a new reference for a preliminary ruling pending from the Belgian court, submitted last year in the case C394/22 oil chart concerning a specific procedural setting. The creditor launched its claim against the insolvency estate in the Netherlands, where the insolvency proceedings were pending against the debtor, and after that lodged the same claim, so-called outside the estate, in another member state, Belgium, with the main objective of requesting, on the basis of that judgment of conviction, payment of the bank guarantee issued in its favor. The Belgian court is seeking clarification whether in substance is excluded from the scope of Brussels regime and therefore falling within the scope of insolvency regulation and action presented as an ordinary claim in a commercial matter without mentioning the debtor's insolvency, which is, however, subject to insolvency proceedings opened in another member state, in the Netherlands, and where the parallel claim against the state is pending. The referring court underlines that the question whether both claims can be brought simultaneously and whether one claim does not exclude the other may be determined in accordance with the insolvency law of the Netherlands. There is also a subsidiary question of compatibility of the provision of the Dutch insolvency law with the jurisdictional rule of the insolvency regulation, if the Dutch law is to be understood as permitting a parallel claim to be brought outside the state, to be brought before the court of another member state than the state where the insolvency proceedings were opened. And this case is likely to bring some clarity to jurisdictional and academic debate whether a separate action seeking declaratory relief is possible in a member state different from the state in which proceedings were opened, and whether the answer to that question is depending on lex concursus. The written stage of the procedure has been closed, and I think we can expect the judgment maybe at the beginning of the next year. In my presentation of today, I will first remind you why it is important to accommodate the proceedings featuring some connection with insolvency within the sphere of one or another regulation, and then move on to the delimitation criteria as they have been could be deducted from the case law of the Court of Justice. So why is it important to accommodate proceedings featuring some connection with insolvency within the sphere of Brussels I or insolvency regulation? Brussels 1A, the same as its predecessor, Brussels regulation and Brussels Convention, exclude from the scopes bankruptcies, proceedings related to the winding up of insolvent companies, compositions, and analogous proceedings. The intention of the European legislator to leave these questions to be regulated by insolvency regulation did not resolve numerous questions concerning applicability of one or another instrument to numerous proceedings which feature some connection with insolvency. The proceedings which derive directly from insolvency proceedings and which are closely linked with them are generally referred to as insolvency-related actions or annex proceedings. These proceedings are independent civil proceedings, and the judgment in these proceedings can be handed down not necessarily by insolvency court, but by another court. There are two principal reasons why it is essential to accommodate proceedings featuring connection with insolvency within the sphere of one or another regulation, since first it determines applicable jurisdictional rules, and secondly, different possibilities of refusing recognition or enforcement of a judgment. The central rule of allocation of competence laid down in Brussels 1A is founded on a well-known principle that jurisdiction is generally based on the defendant's domicile, actor sequitur forum rei, irrespective of his or her nationality. There is a legitimate interest of the defendant to be sued in his domicile. The Court of Justice has held in another context, in the case concerning the law applicable to detrimental acts, interpreting Article 13 of the original insolvency regulation, that a party to a contract who has benefited from a payment made by its contracting partner cannot reasonably be required to foresee that insolvency proceedings may be opened against that contracting partner, and if so, in which member states those proceedings will be opened. And I think that the same rationale, by analogy, is underlying the protection of the general jurisdictional rule in case of insolvency of one of the party, unless there is an insolvency-specific interest which can override the application of general jurisdictional rules. It is therefore necessary to establish whether a certain question falls within the scope of Brussels 1A, which would allow to rely on its jurisdictional rule, and in particular actor sequitur forum rei, or it is subject to vis attractiva concursus principle and therefore falls within the competence of the insolvency court on the jurisdiction based on COMI or the court which opened secondary proceedings. When it comes to jurisdiction and enforcement, after Brussels 1A abolishing exequatur requirement has entered into force, the difference as to regime of recognition and enforcement of judgments under Brussels 1A and insolvency regulation may seem to be marginal. However, Brussels 1A keeps so-called classical grounds of non-enforcement, such as due process rights or irreconcilability with another judgment, whereas insolvency regulation is limited to invoking the public order ground. Therefore, since the grounds of non-enforcement under insolvency regulation and Brussels regime differ, the instrument applicable to annex proceedings still bears an importance for the reasons of different possibilities to challenge the enforcement. Moreover, the exclusion of from the scope of Brussels regime matters deriving directly from insolvency and closely linked to them is an absolute one in the sense that the provisions of Brussels 1A are not applicable, and not even by analogy, to matters falling within insolvency regulation. That also includes provisions of purely procedural nature, such as Article 29 of Brussels 1A regulating lease pendants. Hence, there is either Brussels regime or insolvency, and no overlap between them. Article 6, as you all know, of revised insolvency regulations. Regulation codifies the jurisprudence of the court in Gurden and Deco Marti. This rule is further explained in recital 6 of the preamble to the regulation. The revised insolvency regulation even takes a step further, expressly stating that annex proceedings are excluded from Brussels 1A regulation, although emphasizing that the mere fact that a national procedure is not listed in Annex A should not imply that this procedure is covered by Brussels 1 regulation. It also mentions the classical example of avoidance actions against the defendants in other member states and actions concerning obligations that arise in the course of insolvency proceedings, such as advance payment for costs of the proceedings. One could maybe argue that by indicating in recital 35 avoidance actions specifically against the defendants in other member states, the European legislator intended to take a step into the opposite direction than the court in Schmidt versus Hertel. Just to remind you that in that judgment pronounced prior to the adoption of the new insolvency regulation, the court responded affirmatively to the question whether the courts of the member states within the territory of which main insolvency proceedings have been opened have jurisdiction to hear the action to set transaction aside that is brought against a person whose domicile is not in the member state but in the third state outside the EU. Well, although Schmidt versus Hertel is a great arrival of insolvency universalism, it can be subject to some criticism due to its unilateral character. However, it doesn't seem that the EU legislator intended to modify this universal approach concerning jurisdiction for annex proceedings. Article 6 governing jurisdiction in annex proceedings does not make any distinction between as to its applicability in respect of defendants within the EU or outside the EU. In addition, the word any, the courts shall have jurisdiction to hear any action, strengthens the impression that it is applicable irrespective of the domicile of the defendant, which would be in line with Schmidt versus Hertel. So which actions derive directly from insolvency proceedings and are closely linked with them? The scope of Brussels 1 regulation, which definitely is a cornerstone of the EU private law, is based on a long-standing principle of its general applicability, whereas insolvency regulation sets out independent criteria for the scope of the regulation. In the light of the FTEX case, where the court found that the sphere of EU private law should in principle be gapless, it also became a standing jurisprudence that the regulation Brussels 1A should be broad in scope, whereas insolvency regulation should not be interpreted broadly. In its earlier jurisprudence, starting with the German graphics, the courts used the criteria of the closeness of the link as being decisive for the purpose of the applicability of insolvency regulation. It stated, for instance, that an action brought by a seller based on a reservation of title against a purchaser who is insolvent is neither sufficiently direct nor sufficiently closely linked to insolvency proceedings. In its later jurisprudence, starting with Nickel and Göllner's expedition, and repeated in numerous other cases, Tünkers, Wallach, the court applied the criteria of the legal basis of the action, which it described itself as being decisive. According to that criteria, to identify the area within which an action falls, the relevance should be given not to the procedural context of which that action is part, but to the legal basis of the action. According to that approach, it must be determined whether the right or obligation which forms the basis of the action has its sources in the ordinary rules of civil and commercial law, or in derogating rules specific to insolvency proceedings. And in this context should not be qualified as insolvency related an action brought by an insolvency practitioner on behalf of the divested debtor concerning a pre-existing obligation, or even an obligation which has arisen during insolvency proceedings, but would have arisen in the same manner independently of the proceedings. The court clearly attributed such factors as a locus standi to bring an action by insolvency practitioner, and the fact that the action is brought in the interest of a general body of creditors to the procedural context, and not changing the underlying cause of the action. The term legal basis of the action is not self-explanatory. However, according to the jurisprudence of the court, the insolvency specificity of an action may be determined with the reference to the following criteria. Either the ancillary action is based on insolvency law, meaning that the legal right on which the action is based does not exist in ordinary civil law and is created by the opening of insolvency proceedings. And a classical example of that is an avoidance action, or an action could be based on general rules of civil law, although altered by insolvency law as to its substance. And example of such an action could be the previous article of 64 of the German GmbH Gesetz, now replaced by Article 15b Insolvenzordnung, according to which the managing director of a debtor company must reimburse the payments which he made on behalf of that company after it became insolvent. Such an action, although it exists in general civil or commercial law, requires debtor's insolvency, which in the view of the court constitutes a sufficient derogating factor from the general rules. The rich jurisprudence of the court did not escape some internal contradictions, or at least lack of clarity addressed in an excellent manner by Advocate General Bobek in his conclusions in the case of BNP Paribas Fortis. In that case, the Supreme Court of the Netherlands sought clarification as to legal interpretation of so-called, excuse me my Dutch, Petersgatsen action. The case concerned the embezzlement by a Dutch bailiff of funds, which he transferred from a third-party account in the bank in the Netherlands to a current bank account in Belgium, in that case Paribas Fortis. He later withdrew these funds in cash and was sentenced. Both the bailiff and the company which he had established to carry the activity of the bailiff practice were declared bankrupt in the Netherlands. The liquidator dealing with the insolvency proceedings was seeking the recovery of the sums from Belgian bank in the interest of the general body of creditors for the breach of the bank's statutory obligations and causing losses to creditors. Here you can see the essential characteristics of this action. Thus, such an action derived directly from insolvency proceedings and is closely linked to them. Advocate General first recognized an uncertainty in the case law of the court as regards the exact content of each criterion. The meaning of derives directly from appears to shift in the case law from an assessment of a direct link to the legal basis of the claim in the sense of underlying course of action. To be closely connected with insolvency proceedings points to some kind of proximity test, although it's not entirely clear also which circumstances should be taken into account. As analyzed by Advocate General, this uncertainty is further increased due to a lack of clarity regarding the logical relationship between these criteria, casting doubts as whether there are two independent criteria or actually one mixture of two. The use of and would suggest a logical conjunction. There would be thus two cumulative criteria. Indeed, for instance, in Nickel and Goldner's petition, the court held that the action at issue did not have a direct link with insolvency proceedings, first condition. Therefore, there was no need to examine the closeness of the link, the second condition. However, in other cases, the fact that one of the criteria of the test was unfulfilled did not prevent the court from examining the other one. For instance, in the case of Tunkers, France. Advocate General proposed to the court to reaffirm the test, essentially embraced since Nickel and Goldner's petition. Does the ascertaining of the right or obligation, which forms the basis of the action, have its sources in the ordinary rules of civil and commercial law or in derogating rules specific to insolvency proceedings? The decisive criterion would thus be linked to the first part of the test, whether the legal basis for the action derives directly from insolvency rules. In order to assess the legal basis of the action, what needs to be examined is the nature of the claim in the sense of the cause. Is it an action based on tort, contract, unjust enrichment, or rather on insolvency specific rules? According to Advocate General, the second part of formulation, namely whether the action is closely connected with insolvency proceeding is not really a freestanding criterion, but more of an additional element of verification of the key criterion, namely the legal basis. The close connection would thus allow us to check whether the assessment based on the legal basis is correct. The subordinated nature of the second criterion, close connection, is debatable, in particular in the light of the court's reasoning in F-tax case. Just to remind you that in that case, the court confirmed that the action of the liquidator to set the transaction aside is in principle insolvency related. The question whether the direct link between the action and insolvency proceeding is maintained once the right to have a transaction set aside have been transferred, assigned, and becomes owned by assignee was irrelevant for the court, since it was evident for the court that in any event the exercise by the assignee of the right acquired is no longer closely connected with insolvency proceedings. Hence, absence of close connection is in itself sufficient to qualify an action as not insolvency related, despite the fact that the first limb of the test derives directly would be satisfied. The court in this case, paribus fortis, largely followed the scheme of reasoning proposed by Advocate General, although it did not pronounce itself as to the subordinated nature of the close connection criteria. The court first started by analyzing the legal basis of the action. The purpose of such an action is for the bank to be found liable on the basis of alleged failure to fulfill its monitoring obligations. Hence, it is an action for the liability for a wrongful act. All connected features, such as the fact that the action has been brought by the liquidator, that the proceeds benefit the insolvency estate, that there is no need to examine the individual position of the creditors, were found to form part of the procedural context, hence without relevance. As to the second criteria, the close connection, even if the court recognized a link of that action with insolvency proceedings, since it is an action brought by the liquidator in the interest of the general body of creditors, the court nevertheless attributed a decisive meaning to the fact that an action may be brought by the creditors individually, whether before, during, or after the closure of insolvency proceedings, so that the action cannot be considered to be an inherent result of insolvency. Another case which deserves to be mentioned is Riel. That case originated from the Oberlandesgericht Wien. It concerned applicability of Brussels 1A or insolvency regulation to decide upon an action brought by a Polish creditor, Polish Treasury, for a declaration of the existence of a claim challenged by the Austrian insolvency administrator. Such a declaratory action is provided in the Austrian insolvency legislation, Article 110, and to my understanding, it is a standard procedure which can be initiated by a creditor against all contesting parties when the validity or the rank of the creditor's claim is in dispute. The court ruled in favor of the applicability of insolvency regulation for this type of action. Traditionally, the court started by looking into the legal basis of the action and concluded that such an action for a declaration of the existence of claims is provided for in Article 110 of Austrian Insolvenzordnung, and that constitutes an element of the Austrian insolvency legislation. The court also added that such an action is intended to be brought in the context of insolvency proceedings by creditors participating in those insolvency proceedings in the event of dispute concerning the accuracy or ranking of claims. It is clear that the legal pre-existing basis in terms of substantive law does not change with an introduction of such an action. The underlying claim remains civil or commercial. However, there would be no need for such a creditor's action without the opening of insolvency proceedings against the debtor. The purpose of such an action is to lift the objection as to the existence, accuracy, or ranking of creditor's claim in order to participate in the distribution of debtor's assets. These elements could speak in favor of dominance of insolvency law against the substantive legal nature of the claim. The proximity of such an action with insolvency proceedings is also evident, as it is provided in the context of insolvency legislation. And the pragmatic reasons not to disperse such an actions all around the world also speak in favor of concentration in insolvency forum. To conclude, it seems that the latest case law relating to the criteria of the applicability of Brussels 1A or insolvency regulation demonstrates, I wish to say so, more consistency. A limited scope of vis ad correctiva concursus should not be extended beyond what is necessary to accommodate insolvency specific interests. And it should not undermine the legitimate expectation of the defendant to be sued in his or her domicile. The procedural context of the action, such as the fact that the action is brought by insolvency administrator, that benefits accrue to the estate, are irrelevant. So I hope that although obviously many questions remain unanswered, that we are heading towards clearer rules of the game. And I look forward to the discussion. Thank you very much.